So today we're talking about effective ways to collect rent from our tenants. And essentially, what we want to confirm with you guys is that you've got in your hands a playbook for effectively collecting rent at all times when tenants, particularly tenants who, you know, systematically or characteristically do not pay rent on time. How do you prevent that from ever happening from the first place, or how do you deal with it while you're in the middle of it? So first, we're going to talk about prevention. And what I tell landlords all the time is one easy way to prevent late payment or even non-payment is to have a discussion with the tenant about your course of action before they ever move in. Really, at lease signing, you're having a discussion with your tenants about your process. And so if you say, for example, look, if you're having difficulty paying the rent and I don't have 100% of it in 7 days, well, I'm going to issue a notice to vacate and we're going to have to terminate. And so you let them know absolutely what your line in the sand is, and that the payment of rent is important, and that every time they pay rent late, you're going to charge late fees. And we're going to talk a little bit more about that in a bit, how to enforce that. But if you're not telling them this, I guarantee you they're not paying much attention to it in their lease, especially if they have habitually not paid rent on time. And so by letting them know point blank, this is how I collect rent, this is when I expect rent to be paid, and this is what happens if you don't pay rent, you're likelier to get them to comply. You're likelier to get them, oh yeah, no problem. Rent payment will be on time every time, I promise. And by making sure that you've established, you set out a game plan for your tenants, you're likelier to collect rent each time on time. But unless you're having this conversation, you're leaving it up to them. And sometimes tenants have this misconception, and many landlords do too. And I want to clear the air as to this very common misconception when it comes to late rent. Your rent is due on or before the first of each month. Your lease probably says that in black and white. Rent is owed on or before the first day of each month. And if your lease doesn't say that, you might not have the best lease, but most leases do. They require that rent be paid. But Ernie, I know that rent is not late until I can charge a late fee. Not true. If the lease says that the rent is owed on or before the first, then on the second, it's technically late. That's what the black and white in your lease says. What the law disallows you from doing is accepting the rent on the second or on the third. I'm talking specifically in the state of Texas, but the laws vary across the states. And you may not be allowed to charge late fees until some later date, but that doesn't necessarily extend the due date for the rent. And so make sure that it's clear that you understand what the black and white of your lease says, so that they can understand what the black and white of the lease says. No, the rent is not late once just because late fees are owed. What that provision allows is for you to collect additional money in the event that you do accept the rent from the tenant. You're entitled to additional money at a certain point based on whatever it is your state law or your local jurisdiction will allow. In Texas, you cannot collect a late fee from a tenant until day 4 or after, and you're capped in the state of Texas, depending on whether you're an apartment at 10% or in a single family home at 12%. These numbers can be adjusted. I don't recommend that you play around with these numbers too much unless you know precisely what you are doing. But again, if you, the landlord, don't really understand how late payment works or when a payment is actually late, it's going to be difficult for you to explain that. So make sure you understand the provisions of your lease that establish when payment is late. So the next effective tool that you can have when you're dealing with a tenant who has paid rent late or who owes additional amounts is to issue written notice. Now, what do you mean by additional amounts? Well, you got to stay on top of your rent ledger and make sure that the oldest debt on your rent ledger is being cleared every time you receive money. Now, in my lease and in many good leases in the state of Texas, we have what's called an application of funds clause. And this clause is a pretty common thing that allows landlords to apply money that they receive first to even non-rent obligations on the lease. So if, for example, a tenant didn't pay utilities in the month before and they pay their utilities through you, well, in the subsequent month, when they pay some amount, which they say is 100% exclusively for rent, don't apply this to anything else, or you'll be in big trouble. Well, none of that matters, because once the money is turned over to you, if the lease has an application of funds clause, typically it says very plainly that it doesn't matter how the tenant designates the payment. If they have a debt that's owed from a prior month, you can apply funds from that payment to that debt first, whether that's HOA fees, whether that's repair costs, whether that's pet violations, whether that's utilities or late fees. You can apply the payment first there and then the balance to unpaid rent. So that if a tenant has submitted a payment that leaves a deficiency, you should every single time issue a written notice. Or if a tenant simply hasn't paid or they pay late, and maybe they include all of their fees, every single penny that is owed, that's a good payment, but it's still a late payment, so it's technically a default. And along with explaining to them all the deadlines and your procedures, you should explain to your tenants ahead of time, before those keys are ever handed over, that you will be issuing written notice every single time they violate the lease. So make sure that you do it. So don't just tell them you're going to do it, actually do it every single time and say, look, thanks for submitting the payment. Thanks for paying all of the fees that are owed. Next time, please make sure you pay it all on time. Here is a notice of default because you technically have violated the lease. Repeated instances of default may be met with a notice of termination. Now, for me, I preach a 3 strikes and you're out policy. Now, you may have someone who does this, who pays the rent and 100% of their late fees every single month with diligence. This indicates to me very clearly that your rent is way too low. You haven't charged enough for the rent because this person is very eager to pay not just the base amount of rent, but all of your late fees. So either your rent is too low or your late fee calculation is too low. I see this a lot. You might have $2,000 for monthly rent and the late fee is $50 and then $10 a day thereafter. That is pennies. It's just not enough. If we're using the state of Texas as an example, I recommend to landlords to charge 3% on each day. If we're going day 4, day 5, day 6, and day 7 at 3, 3, 3, and 3, that means that in 4 days they've collected all 12% that the property code allows in the state of Texas. Well, what's 12% of $2,000? Well, we know that 10% is $200, so it's $240 in late penalties. If you did $50 on day 1 and $10 each additional day, it would take you forever to get to the maximum. But remember that your late fee should be prohibitive. And so by enforcing the late fee every single time, the tenant is less likely to do it in the future. But if yours, again, is so low, it doesn't actually make an impact. So your tenant is indicating this to you. Either your rent's too low or your late fee charges are way too low. If they're continually paying them, it hasn't been a prohibitive thing. But 12%, again, of $2,000 is $240. So I would suggest $60 on day 1, $60 on day 2, 3, and 4. And if you get to day 7, because remember, you can't charge late fees until day 4, 4, 5, 6, 7. If you get to day 7, you haven't received rent yet. Now you've got rent and the full amount of your late fees. You're issuing a notice to vacate because we know that inevitably when tenants are this late in the payment process, they're unlikely to actually pay the next month on time, if at all. So you issue that notice to vacate, either to move a tenant who is not a good fit or to let them know you're serious about payment and that not only this month has to be thought of, but that the next month too. You don't want to get all of the current month's rent on the 25th day of the month when you know 6 days later, another rent payment's going to be due. It's not wise to accept that if you don't also anticipate, hey, what about next month? I've got a pending eviction on you that's set for trial in a few weeks. If you want to cure this, you have to cure both. And they may say, well, that's not fair. But remember, what's fair to you? Don't just kick the can down the road. That's typically what happens when landlords accept rent very late in the month. They're just kicking the can down the road because the following month is in jeopardy. So, along with having the talk with your tenant and issuing notice every single time, and then enforcing those late fees, you have to file for eviction. You absolutely have to do it because in Texas, we use a 30 to 45-day plan for eviction. And so if during that time you filed and you've got a certain amount owed, and within that time, maybe another rent payment's owed. And so you have to decide whether it makes sense, even if the tenant can cure all of it, including the subsequent month. You have to decide, does it make sense to keep this tenant in place? If it's an isolated incident, it may. But if this is a habitual thing, if you are constantly having to, track down this tenant to get them to pay on time, to get them to pay in full, then it's probably okay for you to say, sorry, but no thanks. I'm going to go ahead and move on because we're not a good fit. And so, but you have to be resolute. You have to know when you will file your eviction and that you will carry it through. If you're wishy-washy on it, I guarantee you your tenant's going to be wishy-washy on you, and that only breeds frustration and likely additional future economic losses for your business. So I hope these tips are helpful to you, that you're having the talk before you ever hand over that lease, that you are issuing written notice every single time there's a violation, particularly with non-payment or partial payment, and that you are constantly and diligently enforcing those late fees every single time. And then finally, you know your line in the sand when it comes to eviction, and you are filing that eviction and moving on from tenants instead of just kicking the can down the road and allowing them to be bad tenants over and over and over. All right. Bree the guy talking about this very thing in Austin, and we hear this. Well, I appreciate that. Thanks. That's a very kind statement. I'm glad you were able to use our prior comments and our content to prevent things. And naturally, non-payment and lease violations and eviction, that's a bad situation. But so many times we jump in when that bad situation has become a calamity. And it's always best, even if things go bad, to do your best to cut your losses as soon as possible and to move on from a bad tenant so it doesn't turn into something debilitating to your rental business. All right, so we're going to jump into the questions that we had. And the first one is, here we go. How many months can you charge for late fees if the renter is late often? And this is from Dr. Shetty. So here's the thing. You got to utilize that application of funds clause. You are maxed at 12%. And yes, even if you haven't charged any late fees for the entire year of 2024, your lease probably has a non-waiver clause that says, guess what? Just because I haven't enforced this yet doesn't mean I can't. The problem is, what if you get challenged in court and the judge says, whoa, I'm not going to allow this. You didn't enforce this in January or February or March or April or May, June, July, all the way to the end of the year. And now you want to enforce this? I don't see this as just. Again, it says it in the black and white, but the fact that you waited so long, there is a doctrine in the law known as the doctrine of latches. And I don't know that it necessarily applies in this situation just because you waited a few months to enforce it, but it might. And a judge might not see kindly to you waiting multiple months before you finally enforce this provision. So my recommendation is, while you can technically enforce it, you really should be enforcing it within 30 days. Use that application of funds clause. If they had late fees in the prior month, when you receive the rent in the current month, apply it first there. And now you're not dealing with late fees anymore. Now you're dealing with a rent deficiency, which the courts accept every single time. There is no such thing as unpaid rent as waivable in the court, generally speaking. In the courts, if they didn't pay the full amount of rent, they owe that to you. If you applied their payment first to old debt, and you can establish to the court that you did it in conformity with the lease and you did it consistently throughout the tenancy, it's not a problem. If you decide to enforce provisions in a lease late in the tenancy, you might have a problem. So, yes, technically, you're good throughout the tenancy, but I recommend do it on a monthly basis. You get money, apply it first to old debt. Next question. If the renter is late for a couple of months and doesn't pay the late fees, is eviction a feasible option? Not if the balance sheet shows late fees are what are owed. And this is where having a good ledger is absolutely key. If your ledger shows that fee for month one, and then rent for month two comes after it, and then payment comes in, well, if for whatever reason you applied your payment exclusively to rent and you left the fee from month one on the ledger as unpaid, that doesn't make sense logically. And so don't ask the court to bail you out if you applied, because your application of funds clause says you can apply it to non-rent, but if you apply it exclusively to rent, well, you can't evict on the basis of late fees alone. So that technical problem should be resolved by you applying the payment first to the oldest debt and then to the current debt. And if there is a deficiency in rent, that's where you are the likeliest to be successful in eviction court. So same scenario, you've got a tenant who hasn't paid their late fees for the last 2 months. Well, guess what happens next month? You're going to get wise and you're going to apply all the rent to those late fees first and then issue a notice to vacate. In fact, this month, you're going to issue a written notice of default that says, by the way, you owe X in unpaid late fees from the month of, whatever those months are. Make sure you remit payment within 5 days or 7 days, something reasonable. And if they don't, then when it comes to January, you're not going to tell them, by the way, I have an application of funds clause, which I'll pull it from the rent. Just do it because the lease already says you can. So once you get that January payment, apply it first to that debt that you've notified them exists, and you're going to be much better off. So I wouldn't move forward with eviction this month. I would set it up for next month and use that application of funds clause. Question 3, how does a private landowner report late fees, non-payment, or eviction on a renter's credit? Okay, in 2018, the law changed. And so since 2018, the judgment, even an eviction judgment, won't show up on a party's credit report. That doesn't happen anymore. It used to, but after 2018, that no longer happens. So since then, in the last 5 years, what's been the basis of getting a judgment? Well, the most important reason you get a judgment in an eviction is to get possession. You need that judgment in order to get possession 9 times out of 10. But the second thing you can do is abstract the judgment. In the state of Texas, if you request what's called an abstract of judgment, and then you record that abstract with the property clerk's records, you create what's called a judgment lien. And sure, it might not come on the credit, but it does pop up in the future when that party seeks to exercise their right to credit for, let's say, a car or a house. And this is where you will get collection, because they will not, or a lender will not allow their collateral to go into jeopardy without them clearing this particular debt. And so for the abstracts that we file, we'll get calls years down the line. We'll get a call from somebody saying, hey, I've got a buyer here. I'm at the title company. They want to purchase a property but need to clear this debt. Can you calculate what the full amount of the debt is? Because remember, it grows with interest. Currently, the interest rate is 8.5%. Can you calculate what the amount of the debt is, including interest, so that my client can pay it off and you can release this lien. And we do this all the time. And so we suggest that you abstract your judgment so that they are collectible. That lasts for 10 years. You don't have to do anything special. It's 10 years. And if during that 10 years, the party buys a house or seeks to buy a house, you might get a call and then get full payment so that they can buy that house. That's our recommendation. Question 4. This comes from Kim Stone Freeman. Can we have how to get Texas to make tenants responsible for destroying property and landlords being able to do something with useless judgments? Asking for a friend. Who can we contact? What representatives? Surely as many landlords as there are in Texas, we can do better than this. So a couple of things. Most of the destruction on property happens over the long haul. I so many times get landlords who come to my office and say, this tenant's been there for 3 years and they have made absolute mess of my property. I can't believe they did this. And my first question to these landlords always is, well, how many times did you inspect the property? And even those who say, well, I was on the property multiple times a year and I kept seeing it. Oh man, it's just getting worse and worse and worse and worse. But they never did anything about it. My strong recommendation is, just like with the rent, that you tell a tenant, look, if I'm going to be on the property at least twice a year just to inspect it. I'm checking the ceiling, I'm checking the appliances, I'm checking the plumbing, I'm checking the walls, the floors, I'm checking everything out to make sure the house is in good condition so that you are comfortable. But really, we're checking it out because we want to make sure they're not destroying the place. And the moment you see any kind of damage, you are issuing a notice of default and saying, look, I'm going to cover this. You're going to pay for it because this is not normal use and it's not ordinary wear and tear. Now, for things that are normal use or ordinary wear and tear, you can't charge that to your tenant. But the things that are caused by their negligence or by their misuse, absolutely you can charge them. So if they burned the kitchen down, guess what? You can go in there, repair it, and any costs that you incur, they are responsible for. But let's say it's not as drastic as burning the kitchen down. Let's say it's a matter of their dog has chewed up the stairs and the wood all around that first step is destroyed. Well, how do you fix that and what's it going to cost? That's a determination you need to make during the tenancy, because that's a repair you need to make during the tenancy. And that's a bill you need to send to your tenant during the tenancy. And guess what? If you send them a repair bill and say, you got 10 days to pay, guess what kicks in again? That application of funds clause. The very next rent payment you get, if you gave them notice and a notice of default and plenty of time to take care of it, and they fail to do it, the first time they pay your rent, bloop, they've cured that debt. And guess what? Now they have a rent deficiency and you're issuing a notice to vacate if they don't cure it. So get on it, inspect, repair, and issue bills to your tenants during the tenancy. That's the most effective way to not come after 3 or 4 years and then have a laundry list of things you want to charge them, but you can't because they're gone. There's no way you're going to effectively get them to pay unless you do it during the tenancy. Every single time, make sure you get it done that way. Okay, question 5. M.A. Crumby from Facebook group asks, would you please cover, before we get to MA's question, you wanted to talk to your state legislature or your state senator? Yeah, that's going to depend where you live or where your property is located. Look them up. It's a very simple search on Google. Find out who represents you, who represents the area where your property is located, and call those representatives and say, hey, I want some changes. Is this what I'd like to do? Is there going to be a committee meeting? Is there something I can attend in Austin? I'm talking about Texas specifically. Is there something I can attend in the state capitol where I can go and testify on behalf of landlords? Representatives want to represent and want to push an agenda that favors their constituents, but you got to reach out to them. Your state representative in Texas, your state senator in Texas, they all work in Austin. They're going to convene in Texas anyway, every odd numbered year. So in 2025, between January and May, they're going to be there. I suggest that you reach out to them in December and say, hey, because their offices should be open right now, and reach out and say, hey, when you reconvene in January, I would like some topic on landlords. That's the way you do it. But if you wait until after next May, they're done and nothing can be done. All right, so MA's question is, would you please cover the legalities involved in taking still photo or video inside an occupied rental? For instance, I need clear proof that the tenant is being obstructive during maintenance visits. The challenge they challenge the legality of my taking a still photo on one occasion. I would like to wear a body cam from this point forward when doing maintenance in occupied units, but I have been unable to find what the laws are and what I would need to add to my lease. I'm aware that I can legally record audio only if I am physically present and have been doing so, but audio doesn't show when someone is physically blocking your path or what you did not physically bump into them when they accused you of doing so. Okay, so a couple of things. First of all, the one very effective thing you can do every time, if you have a tenant who is not following your lease, which allows you to enter to conduct an inspection or to make a repair, especially a repair they requested, you always want to have somebody with you who can confirm that they barred the door. Now, the moment that a tenant says, "You're not coming in, I'm not allowing it," you say, "No problem," and you turn around and you leave. But you immediately issue a written notice and say, "Section X of my lease says I can come in. You prevented me from doing it, and therefore you have violated your lease. I'm coming back on date Y to try again." And then you show up on date Y and they say, "Nope, you're not coming in. That's never going to happen. I'm never going to allow it." No problem. And you turn around and you go and you issue a second notice and you say, "Look, I'm going to come again on date Z. And if you disallow me from coming in again, I will terminate the lease and evict you." And sure enough, you show up on date Z and they say, "Nope, you're not coming in. I'm not going to allow it. I have constitutional rights." Your next step is to issue a notice to vacate and get rid of them. Now, is it possible that they do have a valid basis for not allowing you in? Here's what the rules are in the state of Texas. If you're there for a reasonable purpose and you show up at a reasonable time or a reasonable manner, and you can enter peacefully, you are free to go. But if you are in peace and you show up in a reasonable manner at a reasonable time and have a valid basis to be there, but they disallow you, they are in violation of the lease. However, if you show up at 3 a.m. and think, "Well, it's my property, I can come whenever I want, and I'm up at 3, and so I'm going to make this repair at 3 a.m. A court may not believe with you that that's a reasonable time. If you want to show up every Wednesday, a court may not believe that a visit every single Wednesday is reasonable. And so if you don't have a valid basis or you don't come in a reasonable manner, the tenant might be right. So remember, for your entry to be proper, you got to have a valid basis, you got to come in a reasonable manner, and it's got to be peaceful on your end. If they break the peace, violation, violation, violation. So if you haven't issued violations yet, that's one effective way to correct the behavior. But certain tenants are never going to be corrected. They have to be evicted, right? So 1, 2, 3 strikes, get them out. Now, as far as what you can video, you can preserve copies of your stuff. You probably can't take a picture of them or their children without their permission. So don't try. If you're there to inspect your property and you want to take a picture of the condition of your microwave or your floor or your wall or your ceiling, your bathroom, all of that is perfectly proper. But don't go taking pictures or video of people without their consent. Yes, you can, video the condition of, let's say, the toilet. They contest that it's flushing properly, and you're there, and like, all right, shooting video, test 1, let's see if this thing works. Flush, perfect. We're gonna try it again, perfect. Try it one more time, perfect. And so there you go. You have video confirmation that you adequately addressed the issue with the toilet, and because it's your toilet, you absolutely can video it. Again, when it comes to other people or their personal stuff, I don't believe you have the right to record it. Now, again, let's not get too ticky-tack. If you're going to be in someone's house, inevitably you're going to get some of their stuff. If it's out in the open, that's different. Don't go opening drawers or, going into, closed things that belong exclusively to the tenant. Now you're probably crossing the line with privacy. But as long as you're not doing that, if you're there to make a repair or you're there to inspect, you can photograph and video your stuff. When it comes to them, you probably need their permission before you're able to do it. When it comes to documenting whether they're letting you in or not, have a witness. That's your best bet. A photograph, it's hard to use a photograph to say they're not letting me into the property. But the truth is, you really don't need a photograph. Your notice of default is also good evidence. So if you have a witness and a notice of default, I believe you're set. All right, Charlotte has asked, can a landlord ask for late fees when requesting a judgment for unpaid rent? Apologies if this has already been covered. Don't apologize. We are all on different levels when it comes to our knowledge of these rules. It's going to depend on your state and local jurisdiction. In Texas, late fees, HOA fees, pet costs, even deposits are not part of eviction judgments. They cannot be included, and the court's not going to hear any evidence of them, which is why we strongly suggest that you apply all fees first with your application of funds clause. You get rent, apply it first to old debt and then to rent, because every single time the eviction court can and will award non-payment of rent. Fees outside of rent don't get included. At most, you can recover possession, always, unpaid rent, court costs, and attorney's fees. We like that rule. Next, Tony Marcus asks, what steps do you take to sue a former tenant who will not provide a mailing address? Now, this mailing address is for purposes of sending the security deposit. Here's what the rule says in the state of Texas. Until they give you that forwarding address, you're not required to send them anything. So why you would sue them, I don't know. But if you plan to sue them, say for damage that they left on the property or for unpaid rent that remains unpaid because maybe they moved out before you were able to secure an eviction judgment, you want to go after them, but they won't issue you a mailing address, they're under no obligation to give you a mailing address. But if you know where they work, you don't have to know where they reside. You can sue them and have them served at their place of business, which they very much will dislike, but you can do that. So they can be served anywhere they can be found. Typically, that's at a residence, but it can technically be at their place of business. This doesn't apply to an eviction. The eviction, they have to exclusively be sued and served at the home. But for all other civil lawsuits, yeah, you can sue them at work. You could hire a private process server. And sometimes private process servers can do what's called a skip trace. So if they won't give you an address, you might be able to use services that can provide an address for you. We do that all the time when we're trying to track somebody down, specifically to sue them. We'll find addresses, we'll put it in the hands of a process server, they'll track them down because they can technically serve them anywhere. And they're walking down the street, hey, are you Joe Smith? Yeah, boom, you've been served. So that's another option. Suing them to get their mailing address, that's probably not the best option. And number 8, Jeremy asks, the law office of Ernie Garcia, what's the difference between an ESA and a service animal? What are the legalities of the two? Oh my gosh, I could talk for hours. And absolutely, I've got multiple videos on these topics. But a service animal is the generic term, right? So you can have a service animal that is an ESA. You can have a service animal that is, like a seeing eye dog or, some other, animal that's used for a medical purpose, but it's all the same. The differences aren't really with the animals. The differences are with the person with the disability. So here's what the law says in a nutshell about, how to differentiate. So if the disability is open and obvious, the easy one is the blind person and the seeing eye dog. Don't ask. That one's easy. It's open and obvious how this dog is being used. And it doesn't matter, can you prove that they've gone through 75 hours of training? That's not a thing, right? If they use this animal for that purpose, to help them walk around, they are allowed to use that animal in that way. Their disability is open and obvious, and the use of the animal is open and obvious. You're not allowed to ask questions. Okay. But most disabilities are not open and obvious. And so when that's the case, you are allowed to ask two questions. Number one, do you have any evidence that your health situation requires the use of a service animal? And number two, do you have any evidence that this particular animal, sometimes multiple animals, that this particular animal meets that need or serves that need? So if it's not open and obvious, two questions. Not what do you got? How long have you had it? Oh, it must be terrible. Tell me more about it. You're not allowed to ask that. You're not allowed to ask what kind of treatment they're receiving. No, but you are allowed to ask because they're telling you, I have a disability. Okay, well, do you have any verifiable evidence that your disability requires the use of a service animal and that your service animal meets, or that this service animal meets the need of the service that's needed for your disability? It could be as simple as a letter from their doctor, which says, Joe Smith is my patient, and due to his health condition, he requires the use of Fluffy, his service animal, to meet his medical needs. Boom, done. They don't have to get more explicit than that. You then have to take that document and confirm its validity, because they could have just printed it themselves. But if you can find that medical, that health professional, licensed health professional, if you can find them and confirm that they sent that letter and they say, yep, that's me, and yep, I sent it. That's it. That's as far as you go. If you try finding this doctor or this nurse or this psychiatrist and you can't locate them, you certainly can't confirm that they're even licensed in the state where they claim to be licensed, or they don't return your phone call, or you call the number and it's doo-doo-doo, we're sorry, but the person you called doesn't exist. If any of those things happen, you don't have a confirmed service animal, ESA or otherwise. And so you're allowed to ask the questions if it's not open and obvious. And if you can't confirm the validity of the document that you received, you don't have to allow the animal. And so there are a lot of nuances to this area of the law. That's it in a nutshell. But yes, there are subtle differences, but really the difference comes down to the individual. Is it open and obvious or not? That's basically what it comes down to. Open and obvious, you can ask. Not open and obvious, you can ask two questions. All right, so that's all for the questions that I had before. Let's see. Failure to enforce repeated continuous late payments could be considered acquiescence. Latches, yeah, thank you, Pietro. And that's why I don't recommend it. Because many judges would just say, nope, sorry, you waived all that. Even if you have a non-waiver provision in your lease, a judge, particularly in the justice court, these are courts of equity, and they're going to say, look, it's just not fair that you waited all this time, and now as a gotcha, you're going to get them in the last month. No, I'm not going to allow it. So, and don't be shocked by that. Okay, good day, Ernie. This is from Yvette Robinson. Let's see, it's not about late fees, but my tenant both signed the lease, but I only received documents from the man. Should I press for documents from the woman as well? Well, that's going to come down to what your requirements are for the application. If you said in order for you to be eligible for this rental, I need this information from all applicants. And if they haven't done it, then they haven't met your requirements. If you were vague as to what the eligibility is, that's where landlords get themselves in trouble. I strongly recommend that not only you have your listed criteria for what makes an acceptable applicant, but that you have each applicant sign that criteria, acknowledging that they understand that each one of these must be met before they're even eligible for consideration. And so it's going to come down to how you dealt with them and what expectations you had of them, and whether those were clearly expressed to your tenant. Marisela Cronin asks, "Hi Ernie, are you bilingual?" Sí, yo puedo hablar en español. I know a little bit of Russian, so привет for any of you out there, but I'm by no means a Russian speaker. If you do speak Spanish and you're interested in a bilingual consultation with me or any of our staff, we have multiple attorneys in our office who do speak Spanish, and we actually, our business manager does speak Russian, and so if that's needed, we can actually accommodate that. And so yes, we are bilingual, trilingual on occasion. If you have a consultation that you would like in Spanish, absolutely, we can accommodate that every single day. And it looks like that's it for our questions. I want to thank all of you who joined us live. We have one last question. Will this be replayable? Yes, this will be in our live section on our YouTube channel. For those of you who missed the first half of it, you can catch it there. I'm gonna edit it down a little bit, but the bulk of the content will absolutely be there, replayable for the rest of eternity if YouTube will allow it. I want to thank you all very much. Have a great weekend, and until next time, landlords, happy leasing.